Welcome to Jackson Lewis's podcast, We Get Work. Our podcast identifies issues that influence and impact the workplace and its continuing evolution, and helps answer the question on every organization's mind: how will my business be impacted? Lured by the promise of better productivity and compliance with company policies, employee monitoring tools are gaining a lot of traction among employers. On this episode of We Get Privacy for Work, we discuss the important privacy and legal implications that organizations must consider before implementing employee monitoring tools. Today's hosts are Damon Silver and Joe Lazzarotti, principals respectively in the New York City and Tampa offices of Jackson Lewis, and co-leaders of the Privacy, AI, and Cybersecurity Group. Damon and Joe, the question on everyone's mind today is: how can I take advantage of the new employee monitoring tools while maintaining reasonable privacy safeguards? And how does that impact my organization?
Thank you, Alicia. Welcome to the We Get Privacy podcast. I'm Joe Lazzarotti. I'm joined by my co-host, Damon Silver. Damon and I co-lead the Privacy, Data, and Cybersecurity Group at Jackson Lewis. And in that role, we receive a variety of questions every day from our clients, all of which boil down to the core question of: how do we handle our data safely? In other words, how do we leverage all the great things about data, what data can do for our organizations, without running headfirst into a wall of legal risk? And how do we manage that risk without unnecessarily hindering our business operations?
On each episode of the podcast, Joe and I talk through a common question that we're getting from our clients. And we talk it through in the same way that we would with our clients, meaning with a focus on the practical. What are the legal risks? What options are available to manage those risks? And what should we be mindful of from an execution perspective? So Joe, our question today is: can we video record our employees, review their emails, track where they travel? In other words, can we take advantage of all these various monitoring tools that have come to market that promise things like better productivity and better compliance with company policies and legal obligations? And maybe, Joe, I was thinking a place we could start, since there are so many of these tools coming to market, is maybe with a little overview and discussion of some of the tools that we're being asked about most frequently.
Yeah, I mean, it's a great question. It's kind of like a loaded question, right? I mean, you can even kind of roll back to just even basic. We get a lot of basic questions about simple cameras and audio and, reviewing emails. But I think what you're talking about are some of these platforms that have come out recently where they can capture all of this and pull it together into a single dashboard, and maybe even in some cases leverage AI and other technologies to kind of synthesize and summarize this data for management so that they can see, hey, how exactly are our employees performing? What applications are they using? When are they using them? And based on their organization and the employee's job, get a sense for, at least in their estimation, whether that person is performing in an optimal way or is distracted or is doing things that they shouldn't be doing. I mean, I think that's kind of what we're talking about, right? Those particular types of platforms that are out there, more so now than they have been. But it gets back to the central question of, what's the expectation of privacy that an employee has? And then you get into, depending on the particular platform, certain types of laws get triggered. Just as one example, the types of video could be video that's in the process of capturing that video. It could be capturing a biometric. And so if you are, again, this is just one issue, right? You could be triggering law in Illinois or in Colorado or other states that have specific rules and not even realize it because of how that particular platform is configured. And so it raises an issue that you didn't even think you might be just focused on productivity and didn't realize, hey, we have this biometric issue now that we have to contend with, which may not be necessary for the purpose that you rolled it out.
Yeah, and those are all great points. And I do think, an important starting point with looking at these tools, and this is true, we've talked about this in the context of AI tools more broadly, is to really understand how the tool works and how people are going to use it, or how you as a company are going to use it. Because there are some productivity monitoring tools out there that really go very granular. They might take down every single keystroke that someone makes and every search that they run. They might have to. They might require people to be on camera for some period of time, and the software is analyzing, to your point, whether people are distracted or other indicators of productivity or lack thereof. So understanding what the tool can do is a very important starting point, and related to that, understanding what controls the tool has in place, and what options you have in terms of features you're going to configure. Because sometimes some of the clients I've worked with, they feel like it's an all or nothing. Someone say in an in-house counsel compliance office here, oh my God, this tool is recording everyone's keystrokes. But it may not be the case that feature has to be used. There may be other aspects of the tool that are lower risk and that might provide some similar value, and you can disable some of the more concerning features. So it is beneficial to really understand what the technology is, what it can do, what options you have in terms of how you're going to configure it, and also what options you have in terms of how you're going to use it. And I think, Joe, maybe a place to go from here in terms of how it's going to be used is a discussion of company systems and company devices versus personal systems and personal devices. Because one of the issues that can come up is if you're using these types of tools and you're using them on, say, people log in from home, they're using a personal laptop to do their work or personal phone to do their work as part of a BYOD program, but you're running the monitoring software on those personal devices, that can definitely impact the risk profile of the monitoring because of all this non-business information that might be inadvertently caught up. So maybe you could speak a little bit to that issue of personal versus company devices and systems.
Yeah, I think it obviously gets a lot more sensitive when you're running some type of monitoring type application on a person's personal device. I think, as BYOD has been around for a while. Typically, there's a mobile device management or similar application where the company's activity, email, calendar, and whatnot are kind of contained in an app on the phone. And oftentimes, that's companies are careful not to go beyond that. Obviously, they want to see and make sure that what they're able to see is only that environment that they've directed employees to kind of set up on their phone. But obviously there's some issues with going beyond that and the unintended consequence of getting information that they might not want to have. And I think that's a big part of this is even if it's on the company owned equipment, one of the things that you see is sometimes an employee is having a conversation with a family member talking about a medical condition, and that could technically be genetic information on the genome, and employers generally aren't permitted to collect that or even request it. So certainly that risk is heightened when you have a personal device, and then of course you may even want to think about maybe the more preliminary question is, do you want to have employees using personal devices, and what controls are in place around that device? Because obviously, if you can't monitor it and track it and control it, an employee leaves the company, what happens to that data? So there's almost a threshold question about whether and to what extent to use a personal device, and then if that's the case, how do you want to direct employees to manage that and use their personal device? And then after that, you say, okay, well, we're going to permit you to use the personal device. Here's how we want it to happen, and then the ongoing monitoring and the policies around that to put controls around the data have to be managed. All the while, thinking about, are the data security controls appropriate? If you're talking about a population that's represented by collective bargaining unit, do you have to get the union's approval? Do you have to negotiate something like these are all things that have to certainly be considered. But again, to your point, Damon, whenever you're dealing with a person's personal device, it becomes a little bit more tricky. Doesn't mean you can't do it. It just means that you have to be a little bit more sensitive to it, I think.
Yeah, absolutely. And I think you hit the nail on the head, Joe, in the sense that this issue of collecting extraneous information is one of the big risk factors with using these monitoring tools, especially the ones that are not, more targeted towards certain activities or certain systems, the ones that are very broad based. People do talk about their upcoming medical procedure or a family's medical condition. They talk about their religious beliefs. They may talk about something that tells you about their sexual orientation or their legal off-duty activities or political views. There's all kinds of stuff that's going to come up in the course of people, chatting before a Zoom meeting starts, or on Slack. Just stuff that people between colleagues, where they think they're just speaking offline, so to speak, mention things, and that could all be sort of hoovered up by a monitoring tool. And then you have to think about what happens with that data. Who is going to have access to it? Is it being appropriately secured? How long are you keeping it? Do you have some type of control in place to keep it away from employment decision makers? Because all of a sudden, we may be deemed on notice of someone's sexual orientation or their religious beliefs when previous, or their potential need for an accommodation or leave, when otherwise we would have had a very strong argument as an employer that we had no idea. We weren't on notice of any of those conditions or memberships in protected classes. So there is a lot to think about in terms of how you structure it. And then another piece, and perhaps we can segue into this, is at the front end, as you're thinking about rolling these tools out, or if you've already done it and you're trying to think of how can we better manage our risk going forward. I mean, one big issue is going to be, what type of transparency have you had around your use of these tools? Have you provided people notice? Have you collected their consent? And so, this is something that in some states may be addressed already through an electronic monitoring notice, but there are a lot of states that don't expressly require that you get an employee's consent, and for a lot of businesses, maybe there's very limited language somewhere in their 80-page handbook that mentions something that could cover this. But what are your thoughts, Joe? What are your suggestions to clients you work with on this, around how at the front end, as you're structuring this, you can best protect yourself from a notice consent perspective?
I think the first step is, to your point, it's a great question, is, do you even have to get consent? What's the requirement? Is it just, do you need some type of affirmative consent, something in writing, like a written acknowledgement of monitoring? Or do you have to actually get, a document that says, I consent to X? And there are some states that, like in New York, right, you have to get a written acknowledgement. It's not necessarily a consent, but a written acknowledgement that the company is going to be monitoring certain activities that the employee engages in on their information systems. Interestingly, in California, right, you have to, under the CCPA, if you're subject to the CCPA, the notice or the privacy policy has to express the type of data collected. And when you start thinking about these monitoring tools, they collect a lot of information that you may not have thought about in the normal course of the employment relationship, and potentially, right, even in the customer relationship, because employees may be monitored while they're interacting with customers, and the system would be collecting that information all the same. So I think yeah, but it's interesting, Damon. I'm curious what you think about this, because one of the things that I do see happening, and this kind of ties into the consent issue, but I think it also ties into the overall governance of these products and tools that companies are using, is that it often doesn't start out with the full range of monitoring that a vendor might present to the company. They may start out with, well, we're just going to monitor email. And then the company goes through a vetting process. Hopefully they go through a vetting process to kind of understand the risks and take appropriate steps, due diligence around the tool. But then, 8, 12 months later, the company, the vendor comes back, maybe their direct contact is with the IT department, says, hey, we added this option. we enhance this option. There are some great benefits. We've had a lot of good feedback from customers. There won't be any more cost to the company. Maybe there is, but maybe there isn't. Would you like us to talk to you about it? And maybe the IT department says, yeah, that looks great. I would really help the company. We've been looking for this solution. So yeah, let's start on it next month on August 1st, right? What happens then? Talk about that. I mean, have you dealt with that with clients where they wind up doing that? Because at that point, do they go through the same process to vet it?
Yeah, absolutely. I mean, I'll take it one step further. I was talking to a healthcare client pretty recently, and one of the people I was working with was their director of IT, and then their head of compliance. And they told me that they recently learned, through a service they use to provide. They don't want to have their people in the field using their actual personal cell phones to make calls to patients because, for employee protection reasons, they don't want those numbers out there. So they use one of these services that provide alternative numbers, obscuring of the numbers. And through that service provider, without knowledge of IT or compliance, anyone who is in a position to vet this, the vendor started making available to all the users of these numbers an option to record and transcribe these calls. And so employees out in the field thought, they assumed that they were seeing this option being presented to them, that it must be company approved. And so they were just recording and transcribing all their interactions with patients. And it had been going on for a couple of months before the company even realized it was happening. So it may even be the case that it's not like the vendor formally comes back and says, hey, we've made this feature available. It just may be there for end users to just start using as part of, because probably what happened was the company just did a normal upgrade that had been pushed out by the vendor of the service, and that caused this option to be presented. So it's definitely something to be wary of, and in thinking this through with clients, given the fact that one, you just can't know everything that's going on, and two, you don't want to have to keep revisiting the same issue over and over and over again. To some degree, you might have to, but you want to cut down on that, is at the front end to really try and take a holistic, longer term view. How might this tool be used? What features is the vendor talking about rolling out? Because oftentimes these vendors will preview what they're working on and what they think will be available, and they're making it a selling point. But also, of course, it does have downstream privacy and other types of risk. And trying to do that thought exercise beforehand and develop a framework that is a little more adaptable than just addressing the very narrow problem that might be in front of you at that point in time. And that way you are better protected in case the tool starts being used in ways you didn't anticipate, or the tool itself changes because new features have been made available. And it's not perfect. There are going to be things that you do have to revisit from time to time, particularly if you're using technology that's fast evolving. But by taking that step back and looking bigger picture, you can get out in front of a lot of those things in a more effective way.
So it sounds like, and maybe this is a good place to kind of stop on this topic that we could probably talk for hours on, but
yeah, you
probably can do it. It's just that there's some really important things to think about, not the least of which is what exactly you're doing and what is the technology doing, because that can trigger a whole range of obligations.
Yeah, I think that's right. I think it's a great place to wrap up. I mean, on that exact point, just maybe one more thing to throw out there is I've been getting a lot of questions, like the last couple of weeks, all of a sudden, tons of questions about AI-powered dash cams that do video, out the front, video into the cabin, and also are looking at things like harshness of braking and wavering within a lane and other indicators. The driver might be tired or might be overly aggressive. And so, one thing that's come up a number of times is, one, in a few instances, the client didn't realize there was an AI component. And in a few instances, they didn't realize that the default was that this tool would also capture audio. They were thinking of it purely as, this is video. And if we put up a little sticker in the car saying, this vehicle is subject to video surveillance, aren't we good? And if that was all that was happening with the tool, sure, you would be good. But, this is another example of there probably is more, or at least could be more to the tool than meets the eye, or that, than what you were looking for initially. And understanding the full picture of what you're purchasing and making available to your employees is very important, because otherwise a lot of the steps you're taking, the policies you're rolling out, they may address the problem you thought you were addressing, but leaving completely open other problems that you weren't aware of because it just wasn't where your focus was. So maybe on that note, Joe, we'll wrap things up for this discussion. But as always, if you have any thoughts for us on additional topics that we can cover, or thoughts on this topic, you can email us at privacy@jacksonlewis.com. Thanks, Joe.
Thanks, Dan.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com.